Thank you. Good evening, ladies and gentlemen. I'm Michael Rossi, Chairman of the Aquifer Protection Agency. I would like to call our regular meeting, regular quarterly meeting to order. Will the clerk please call the roll?
Ellen Dahlgren. Here. Eddie Alberino.
Here.
Mike Florio.
Here.
Martin Jaffe.
Here.
Alan Cravis. Adam Moore.
Here.
Cynthia Lettieri. Walter Bo Clark.
Here.
Jay Mandel.
Here.
Zach Flurry.
Okay. I believe we've got two seats I can put,
Jay and either Alan Cravis or Cynthia Lettieri.
okay, put Jay in, for, Ellen Craven,
Thank you, sir.
okay? Is Bo an alternate or full member? Alternate. Okay, well, then I can see Bo for Mike.
Oh, okay. Thank you.
Okay. With that, we have a simple agenda, review and approval of the minutes from April, where we reviewed and approved the minutes from January. So is there any comments on the agenda? Does anybody remember that day?
Good. Comments on the agenda or a motion?
A motion to approve.
Second.
Second. Right, here. Second.
Thank
Thank you. With that, any discussion? We'll do this with a voice vote. All those in favor of approval?
Aye.
Opposed? Abstaining? Motion carries.
I wasn't here.
You weren't here, you're abstaining? Okay, one abstention. Thank you. Any old business? No. Did we get any new business for you today? No. Okay, I would entertain a motion to adjourn. So move. So move. Okay. Second. Okay. Discussion. No, all in favor of adjournment? Aye. Both, same, motion carries. You can stop the recording for a minute. So now we go. Now you should be able to wait for the next.
Oh, sorry. Sorry.
Stop the recording.
Yep, sorry. Pause. Just pause it.
Okay, so. It doesn't look like it. It looks like it's still recording. Thank you, everyone. I'm Michael Rossi, Chairman of the Planning and Zoning Commission. I would like to call this regular meeting to order. Will the clerk please call the roll?
Ellen Dahlgren.
I'm here.
Eddie Alberino.
I'm also here.
Mike Florio.
Here.
Martin Jaffe.
Here.
Alan Cravis. Adam Moore.
Here.
Cynthia Lettieri.
Here.
Walter Bo Clark.
Here.
Jay Mandel.
Here.
Zach Flurry.
Here.
Thank you.
I would like to see Bo for Mike Newton
Thank you, sir.
and Jay for travel.
Thank you.
Okay.
Excuse me, Mr. Chairman, if you may, could we introduce the new members?
We could do that. It seems to be appropriate. So we got two new members.
Two new members.
Well,
Not both,
both
right here,
Cynthia.
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 Cynthia, I get to figure out regularly.
From Zach. Floored, actually. It's floored.
Floored.
Yeah.
Thank you. I apologize.
Okay.
That's nice.
Thank you.
Thank you.
Yeah. Now, Bo's returning.
Oh, well, yeah, we sucked them right back in.
Okay, with that, we have our review of the minutes from the June 12th meeting. Were there any comments or corrections to those minutes?
No, sir.
Seeing none or hearing none, I would entertain a motion to approve.
So motion?
Second.
Second, thank you. Okay. All those in favor?
Aye.
Okay, thank you. Anyone abstaining also? Thank you.
Can you just, one more, we're just fixing a technical.
Okay, I'll wait a moment. Yeah, you need to admit somebody. No, go down and get the participant button and that'll do it. Wow, look at that. There you go.
So just a note for folks, as we're using, so this meeting owl will spin and record people as they're talking. The more we can stick to one person at a time, the better, and the louder people speak, the better it will pick up. We're still waiting on some long records, but it should help Gary to see who's talking and go from there.
Where'd she come from?
Okay. Item 3, chair's comments. I just want to welcome everybody back to in-person meetings. Hopefully, we can recognize each other after all these years. It's been a long, long time. I appreciate getting back together. Okay. Item 4, receipt of applications. The first one is planning and zoning 23-13 for 23 West Main Street. This is a change of use from medical office to tea lounge and retail. Is there an agent or applicant here for this? Yeah, okay, Peter, please step forward and give us a summary of, well, actually, let me see how we have this. Right now, we're just going to receive it, and then when we get to review of applications, we'll have you present it. Okay. So I would like a motion. You can sit down. I'll take care of it. I'm sorry, I got out of order.
I'd like to make a motion for the chairman to receive PZC -23-13, 23 West Main Street.
Okay. Second by Bo. Any discussion? All in favor?
Aye.
Opposed? Abstaining? Motion carries. Thank you. The next one is PZC 23-18. Zoning regulation amendment to add multifamily adaptive reuse zone. This will need to be received and scheduled for public hearing for next month, August 14th. Thank you. Go ahead.
I'll move to receive PZC -23-18 and schedule it for public hearing on August 14 August 2020.
Thank you.
I'll second that.
Thank you. There, any discussion? Is there an agent or applicant here for this that would like to briefly tell us what we're doing or what you're doing?
There is no applicant here tonight. This is essentially, the two applications are linked. They're two distinct applications. The public hearing can occur at the same time, but separate action is required on both. This is related to the 345 East Main Street pre-application meeting that the commission previously held for the multifamily housing units with Victorian Village.
They want to tear that down,
The blue, yeah.
so they want to do the
The two applications
Yeah.
are zoning amendment.
zoning amendment change.
And some in zone.
Correct. So it's the zoning and the landing of the zone, and then a subsequent step, if
Right.
these were to be approved,
Okay.
would be to come back for an application to actually cite and work on the site improvements themselves. So you'll see information in the application that gives you an idea of what's coming in the site application, but this is true, this is simply the zoning and the landing of the
Yeah, they
zone.
want to change that zoning on it.
Correct.
Okay.
So all those in favor of receiving this? Opposed? Nay, motion carries. Okay, and then the second one is PCC 23-19. the zoning map amendment, rezone the subject property. Again, can I have a motion to receive and schedule for public hearing on the, August 14th?
Yes, I'll make a motion to accept. PZC 23-19 zoning map amendment to rezone subject property.
Okay,
And schedule the public hearing.
And schedule, I'm sorry,
Yeah,
sorry.
and I'll
Schedule a
second.
public hearing.
And I'll second.
thank you. Any discussion? All those in favor?
Aye.
Opposed? Abstaining? Motion carries. Thank you. I would like to ask, if we could reorder our agenda. Because I believe we have a lawyer here for item 7. So to reorder the agenda to move item 7 up before, the public hearing.
Yes, that,
So
so we'll second.
Second, okay. Any discussion? All those in favor?
Aye.
Opposed? Abstaining? Motion carries. Okay. So we're looking at the administrative review of 11 Lindera Lane. Let's see, is there an agent, for the applicant there?
Hi, good evening, Ed Casella. I know we've spent a lot of time going through this, so, we, since the last meeting, put together a draft, action for the commission, resolution motion type thing, as well as provided an updated conservation easement, in light of the discussion we had last month. So I don't know if there's any other questions that you have for us, or if you'd like us to present additional information, but I know Carrie Olson is here representing the town. So, you know, I don't have really anything further to look forward at this point in time.
Thank you, Ed. Carrie, do you have comments on this?
So, the only thing I would like to add, is that Abby sent me, Attorney Casella's drafts. We were in agreement that there needed to be some modifications. I understand that, after talking to Abby, she has made some red line changes that I am in support of. I think most notably, the concerns are suggesting that a former agent of the town approved of things that we don't have any verification for, notwithstanding. It's up to this commission to determine whether they feel that it's appropriate to approve it, but we didn't feel it was appropriate to suggest that an agent of the town had actually approved of the conservation easement adjustments. That's up to you. And so we modified both the motion, if you will, as well as the revisions to the proposed conservation easement to reflect what we felt was more appropriate. And I would encourage the commission, if they are inclined to amend the conservation easement, that they adopt the version that has been provided to you by Abby.
Thank you. Abby, can you tell us a little bit about what the changes you made were?
Sure, so the first document is the motion, that references sort of the history of what's going on with the property and what's been filed in the land records associated with it. Some of the, so if there's a 2-page document, in the third paragraph, we did as a takeaway, we clarified the last sentence to read that the conservation restriction line apart to 40 feet in the vicinity of the driveway, because that 40-foot modification in 2009 wasn't around the entire easement area. So we clarified that. And I know that there's been a lot of discussion about previous ZEO's position or what may have happened that's not in our town record. Because we don't have a particular record of town approval, we've taken out those references. It doesn't change the outcome of the action. It just means that the decision the commission makes doesn't codify something for which we have no concrete documentation. That's really all that is. So any references to that particular staff member has been removed. A couple of, in the second to last paragraph, left, whereas, we just added in the 2012 conservation restriction just to make sure it was clear which year we were talking about. Item 2, so once we get into the now therefore, item 2, we removed the line, the house was built closer to the conservation restriction line than originally contemplated. The reason that was removed was because the application for building permit and the as-built actually showed it in the same location. I think it in reality may have been farther back than folks anticipated or understood when the property was being purchased, and that's very clear. What we're trying to do here is marry the language in a commission motion to the record that we have on file. Again, still gets the job done in terms of an approval, if that's where the commission is intending to go with this. But we try to get the record as clean as we can on that. So there was some additional language relative to some of the conversational elements of previous actions of an officer of the town that were removed, and tried to sort of say, again, activation of the certificate of occupancy on the 18th, 2010, and subsequent sale became apparent, and then left the rest of that language in place, and then just a couple of small grammatical pieces to it. And again, the number 3, same thing, we removed the reference to the particular staff member, but put in these existing encroachments have been in place since 2010. So trying to keep with that necessity of finding a unique circumstance that this has been in place, it's been in place for a very long time, modifying it, any kind of physical change to the land at this point to restore something would be impractical for the property owners and perhaps a little bit of a reach. And so we don't want that to happen here. So we wanted to
Just a one-shot deal on that.
yes.
One
So,
shot.
yeah.
Is that in this?
So it's in, so it's,
Item 3 sort of gets that.
yeah, so it's,
Modification is unique because.
and it's also, if we go to the next document in the amended declaration of conservation restriction. So there's a couple brief things that we'll need to change. One, there's a note on page 2 in the first piece of the now therefore that references the map revised through 6/29/2023. That date will need to be modified if the recommendation that we put forward that the proposed pool be removed from this plan at this time.
Divide 6/29/20.
Yeah, so that'll just have to be updated when that pool gets taken off of the plan. And then the only other piece for the conservation restriction was, item D, so within the restricted premises, the owners are subject to restrictions as follows. There's 4 items. D, I just wanted to point out, is slightly modified from the original 2002 restriction. And so I've added that language here in case the commission wants to have a conversation with Attorney Casella about that. In that next paragraph, that's where it says, and we have some elements here that there's no, yeah, I'm going somewhere.
You're cutting?
Let's see. So yeah, so what the original said was no cutting or removal of any vegetation, including both alive and dead trees, except under the direction of the grantee or the express prior written consent of the grantee. And so that was changed to the opinion of the licensed arborist.
Right.
And so the commission needs to be comfortable with that language.
Right.
If I may, Mr. Chairman, again, I encourage you to accept the changes that we have proposed. And in particular, the plan that has been submitted to you that shows a pool. My concern about approving that plan is that there's going to be a suggestion, as there was with prior plans relating to this property, that you're approving of that pool. And that's a whole different ballgame. That needs to come before you as its own separate application. It needs to go before the Inland Wetlands Commission. And so it's critical that the plan be revised to remove the pool, at least in my opinion.
Thank you very much.
You're telling us to remove the pool, you're suggesting to remove the pool plan from that property?
So the plan itself, and forgive me, Abby, speak up. I assume Attorney Casella was in accord with this. There is no pool currently. And it's very important I think at this juncture, that whatever decision you make, if you agree to revise the conservation easement, that it not be assumed that by approving the plan that was submitted with all of the documentation, that you are, quote, approving of the pool. Again, that needs to go to its own site
We have
plan.
no objection to what the town is suggesting in terms of removing the pool from the plan that's going to be recorded on the land records. So we don't object to that. We understand there's an additional approval process for any pool that could potentially.
Yeah, that goes to the inland wetlands.
Yes, exactly. So we don't have any issue.
But I just gotta say, because I remember everything that was proposed. The pool was on that original sketch.
Correct.
And that was 2012. Okay, I'm like,
But there isn't any records the pool was ever approved.
it's. Well, I'm saying, Mr. Chairman, all due respect, it was on that piece of paper, all right? It was on the
As a proposed pool.
proposed pool,
But it never got approved.
okay? But
So, right, it's,
Removing ambiguity of this.
right,
That's let's.
right.
Yeah.
That's what we're doing.
I would like to talk about the tree cutting for just a moment if I can. One of the challenges with the language is there are 3 grantees. So if we needed to remove a tree because it's dead, then, you have to go through this kind of convoluted process of getting P and Z, Town of Clinton and Red Wing to sign off on it. That's why we revised the language to make it a little less burdensome, that if a licensed arborist comes out and says this tree is dead, you can remove it, then no one will be able.
yeah, we have a license arborist in town. That does it. He
Yeah.
comes out. And it says, it's dead, or, dead. Gary was dead, right? Correct?
Right. But that's the question,
I
that's.
said, we have a town,
Yeah, there could be any.
it could be anybody, you're right, Ellen, yes, could be anybody, but we do have some people down. That knows if the tree is dead or not, if it's a danger, just. Fall and,
And also if you do removal within 100 feet
Yeah.
of the wetlands, trees, you'd be wetlands.
yeah.
Right.
So there's a couple levels of review in that, or
Right.
from the professional piece and from a town piece that could be simplified, should that be needed, so. I don't know that that's necessarily, as long as Attorney Olson doesn't have any concern about a different condition in this easement versus the 2002 that covers the remainder of the Hooper's Landing Phase 1 and 2 subdivisions. Because this is specific to this property only, so the others are still subject to that original provision that they have to get granting approval. And we're not here we can't discuss modifying those rights for those folks. But as long as there's no conflict that you can see, I wouldn't necessarily have an objection to staff to that.
I have a question to the attorney. Basically, what Abby said, if in fact this conservation easement is common to all the other lots that are similarly around the subject lot, why isn't this a re-subdivision application? I mean, why are we playing around with language of the restrictive covenant instead of looking at it as a re-subdivision? Because functionally, it seems to act almost as if it were spot zoning, that you're treating one lot differently than all the other surrounding lots without any real justification for treating it any different.
So I'll address that in 3 parts. First of all, I too agree with you that there is a real concern that the approval of this modification will have a ripple effect. Now, there has been representations made that certain adjustments were made with the authorization of a former town staff official. We don't have anything to back that up, but my understanding is that the majority of this commission was inclined to give consideration to this particular property owner. My understanding is that the plan that was approved by Mr. Lane was solely for the location of, I believe it was a propane tank, and some other improvements. And the fact that that plan happened to have a pool on it, I believe, led the applicant to believe that that was being approved. I think as a matter of law, that's not necessarily true. However, if under all of the circumstances and everything that's been presented to you by Attorney Casella and this property owner, you believe that there was a significant misunderstanding and you're inclined to give them the benefit of the doubt, my position would be, as a land use attorney and attorney for the town, that you be very cognizant of what type of precedent you might be setting. And so I completely agree with the comments that have been made that you need to be very careful about giving special credence to one lot owner in this subdivision when there are many other, right, properties that are subject to the same conservation easements. And so you do need to be very, I think, critical of, if you're inclined to give them the benefit of the doubt, to limit the benefit of the doubt to what is absolutely necessary to alleviate, almost like a variance, to alleviate what you perceive to be any foibles that might have come before you. But again, one of the things I said to Abby while we were discussing these draft documents was that it was important that she go back and compare what is being offered in the revised conservation easement to what was originally imposed. And so, as a land use attorney, my suggestion would be that the revised conservation easement should reflect to the greatest extent possible what was originally imposed on all of the lots in the subdivision. The only reason, point two, that I would say it's not a re-subdivision is that it is my understanding, and correct me if I'm wrong, Abby, that none of this conservation easement area was preserved for public use. And so under the definition of a re-subdivision, I don't know that this would qualify for that. And Abby and I had discussed this. I don't think it's a re-subdivision based on the knowledge and the information that's been provided to me. But I do caution you, there are other units in this subdivision who may come back to you and ask for the same consideration. So I feel, to the extent you're inclined to modify it, it should be as close to what was originally imposed as possible.
One additional question, I guess. If in fact we should treat it like a variance, variance requires some type of hardship, some type of harm suffered to the landowner. And here the prior to alleged actions were to the benefit of the landowner. The landowner was able to pave a driveway that none of his neighbors were able to pave because they were in the restricted area. The neighbor was able to put in a generator and propane tank that none of the neighboring lots were able to do because of the restrictive covenant. Why should we keep bending the rules to favor this particular landowner and not the neighbor? I don't understand.
So I'm going to say that I appreciate all of your concerns, but they all impact your decision, not mine. Again, as a land use attorney, my opinion is that there is not sufficient justification to modify the conservation easement in this case, based on the information that's been provided to me. And keep in mind, I wasn't here at the prior hearing, so I could be wrong. And there may be extenuating circumstances or sympathies that go to this particular property owner, of which I am not aware. But again, my position on this is that all similarly situated property owners should be treated alike. That's the fair and equitable thing to do. So So I hear what you're saying. But that's not, at this point, really a legal question for me, as much as it is a question for all of you.
Mr. Chairman, may I ask you a question?
You may ask.
Your Honor, your attorney, whatever.
Oh, Your Honor, oh my God, I've been elevated. Thank you.
Okay. Have you been to the property?
I'm sorry.
Have you been to the property?
I have not been physically to the property. I have seen aerials of it and also the maps and plans, as well as Abby's
Have you seen the
of
original wetlands delineation? The original. Where they have, goes up to the back porch. If he goes out his back porch, he's in the land of conservation, right out his back door, So.
as I said, those types of considerations are for you. I'm just the lawyer, right?
Okay,
So it's up to you to determine if this is an appropriate modification. My only point as an attorney is that you have to understand that there may be others that come along who want similar consideration, and you may have to address that and be able to distinguish why you perhaps granted a modification to this particular property owner and not to everybody in the subdivision.
right, that's why I said this is like one and done to Mr. Chairman. The land, when he bought that land, he didn't know that the conservation goes right up to his back porch. So he did, they did Red Wing made concessions and gave him the actual land for.
That's for us to do.
Right, so that's all I'm saying, unless you've been there and seen it with your own eyes. Unless you've been there and seen it with your own eyes, you can see what the guys are going through. Okay.
Again, my point is that this is not a decision that I have the right to make. This is up to you. Absolutely up to you. Based on the facts that have been presented to you, based on the circumstances that you find compelling. I cannot tell you what decision to make. I can only say that you do need to be cognizant of what could be a ripple effect down the road. And if there's enough distinguishing factors for this particular property, then you will make that judgment. It's ultimately your call. And obviously it's contingent upon the town and Red Wing also buying into it. But again, my critical things are doing things like approving of a plan that has a pool on it, knowing the history of this case, where somebody comes in for approval of a propane tank and assumes that that's justification for a revision to a conservation easement. My concern is that having a plan before you tonight that has a pool on it will later be, you'll later be charged with having approved of the pool, which I don't think is appropriate. And I also don't think it's appropriate to include in any kind of resolution on behalf of this commission, any comments allegedly made by Mr. Lane without him here to justify or validate. And we, again, Abby has worked tirelessly on trying to put all of this together. And there is just no evidence in the record that Mr. Lane approved of any modifications to the conservation easement. Notwithstanding, that doesn't mean you can't. And if the town and Red Wing agrees with it, that's fine. But to have a resolution that suggests that Mr. Lane made certain approvals, to me, without any record to reflect that, would not be appropriate.
Thank you.
I have one question.
Yes.
Would approval of this modification to the conservation easement have any conflict with state wetlands regulations? I assume that's been reviewed.
State weapons? I'm sorry, did I miss?
Wetlands.
Oh, wetlands. Sorry about that.
Don't
So,
need
Yeah, please.
I mean, like, are we gonna have a gun range now? No, I'm kidding. So anyway, so wetlands obviously is not within your jurisdiction. That's within the Wetlands Commission, which is one of the reasons we were so concerned about showing this pool on the plan. And I understand that the applicant has agreed to remove that and come before you for an actual approval, and the Wetlands Commission for an actual approval. Changing the conservation easement really doesn't affect the regulated area, because again, that falls under the Wetlands Agency. So whether you have a conservation easement there or no conservation easement, they're still obliged to comply with all wetlands regulations. And so,
Thank you.
Yeah.
Thank you.
Thank you very much.
Thank you. very
you're
much.
welcome.
So you're our new town attorney. What is your name?
Carrie
What is your
Olson.
name?
You know what? I'm ashamed that you don't know who I am. Been representing the town for a while now, but my name is Carrie Olson. I'm a partner with Martha Kalina, and I'm a land use and municipal attorney, 25 years now. So, and it's a delight to meet all of you and see you all sitting there together in person.
Thank you.
Thank you.
You're
Okay,
welcome.
so at this point then,
Can I just.
that's what I'm going to do.
Okay.
Go ahead.
I just want to kind of sum up what we're looking for here to make sure everybody understands and is on the same page. And, you know, as far as the modifications go, we've talked about our request for a licensed arborist. If you approved it the way it is now to make it consistent with the entire subdivision, we would, you know, we're not going to object to that. We presented our reason as to why we think our language is a little better from a practical perspective. But if it's an impediment, it'll make things inconsistent with the other lots. You know, we're not gonna dispute that. I think the big question here, not the big question, but I hope you all understand. We can remove the language about Tom Lane approving it, but Tom Lane, there's a Mylar filed on the land record with a modified conservation easement to allow the driveway to go through before the CO was issued, before the house was sold, that said the conservation line was modified by this wetland enforcement agent, right? We had similar discussions and meetings with him where he said, okay, this new line is okay. This is what was happening. In 2012, we have 3 pools that he approved administratively within the wetlands upland review area. Whether it's in, we understand it's not in the files, right? But this is what was going on. And this is what is directly impacting these people and their ability to use their property in the way they thought they could for the last 11 years, right? So that's why we're here. That's why we've gone to Red Wing. Ask them, what do you think? Here's the situation. And they said, okay, yeah, we understand that. That's why we've been working with the town. Just to clarify that the propane generator question, the reason that's relevant is because we spent June, July, August, September into October of 2012, working with Tom Lane to reach the resolution that we did. Right, and I'm testifying, this is my, you know, it's not in the file, but this is exactly what happened. 6 months later, he went for the propane approval for the retaining wall and the other things that were in the conservation easement, and Tom Lane signed off on it with that plan, right? Using that plan. Would he have signed off on that if he hadn't already approved the modification later on? That's the evidence that we want you to say, okay. The circumstances that have been applied to the Randys are different than what's happened to the other property owners in that neighborhood. And that's what gives you the basis to say, yes, we'll modify your conservation line. But if the next person comes, they're not going to have the fact pattern that we have, right? We have a very specific, and parts of it are indeed documented. right? That those approvals for the propane and retaining walls and things like that is after the 2012 conservation. There's a note on the Mylar that was recorded on the land records that said this line has been changed. So we have things that we can hang our hat on that nobody else is going to have, that, you know, in the resolution that was drafted, you can rely on when the next person comes and say, sorry, you don't have that, you know, you don't have all of the facts that they do. So that's the basis of what we believe gives you the ability to make this modification.
Mr. Chairman, that's what I kept bringing up. 2012. I'm bringing up 2012 with the map. And on it, it says proposed pool. That was filed in 2012. Whether Tom Lane did his due diligence or not, it's irrelevant to me. But I see several documents that Tom Lane, acting as an agent.
I don't wanna,
No,
we're talking about.
I'm not bringing up Tom. I'm just saying.
Yeah, but you are.
No. Eddie Alberino, I was acting wetlands officer for a little while, and I signed off as an agent, the agent for Tom McLean. That's why it was on my letter, So I'm just saying, when someone signs off on something like that, that person should be held accountable. That's all I'm saying, Mr. Chairman. And if you go back to 2012, you'll see that letter.
Okay. With this, I would prefer to let the discussion amongst members about the value of this agreement and the proposed language move forward. So, go ahead.
So I'm in agreement with the amendments that the land use office has made to this. I think that it's fair and equitable, while we remove references to Tom Lane and potentially hearsay. I do believe that the town has some culpability in how we got here. And I would like to make a motion to approve the amended declaration of conservation restrictions as amended by the land use office.
Okay, thank you.
I would like to second that.
Further discussion.
I have one question, I get, sorry.
Ellen jumped in first.
That's all right. I would request that, if the board modify this motion to specifically to reference the updated map, which will not show the swimming pool.
I assume that this is the motion, if I read the whole thing.
So I think you could adopt the amended declaration, sorry. So there are particular amended findings for the basis of the decision that the commission includes as follows. So it would be the amended version of that document. The only question that I have, and then you know, subject to the modification, staff modifications to the draft amended declaration of conservation restrictions, and the only point of clarification there that I would ask is whether or not in those 4 points, that 2002 comparison, if we mean the language as Attorney Casella has proposed it with the licensed arborist, or if we mean the
I
2000.
think we need to keep that consistent with the
Yeah.
rest of the.
So we would add that finding, we would add that modification into the restriction, and then with the additional amendment of the updated data plan to remove the proposed.
Do you agree with that?
I do.
Okay. Then,
Yep, go, yeah,
okay. Thank you.
And I have one question, I guess, for the attorney, just for clarity. She had mentioned before the mentioned ZBA and whether variance, and I'm assuming because this isn't a zoning regulation, that they really, the ZBA would not be the appropriate.
No.
method. Okay, I just want to get that for the reference.
Thank you.
Yeah, so I don't mean to assume or suggest that you are a zoning board of appeals. What I'm suggesting is that if you're going to deviate from the conservation restrictions, it would be helpful, I think, for you to use the same sort of tenets in that it should be only the minimum required to alleviate what you perceive to be the hardship that this property owner has suffered from poor communication or whatever it is. you know, again, to that end, it's really important in my mind that any modifications to the conservation easement as closely reflect the same requirements for the rest of the property owners as possible. Just again, to alleviate somebody coming back later and saying, hey, you did it for them, do it for me. And so, but again, the ultimate decision is yours. And if I can be of any additional assistance, just let me know.
Appreciate it. Unfortunately, we're in a motion and you're not seated, so I can't call them.
Nor can I make a decision. All I can do is give you legal.
So I apologize. Go
I
ahead.
just want to make a point of clarification. So we are solely deciding right now whether to accept Attorney Casella's version or accept the Newtown version.
Well, no, we're voting on the town version.
We are, but that's what I'm
Yes.
asking. So we're either, so we're gonna accept the Newtown version and then we will decide if we want to change the.
The motion is to approve the new town version, not a choice between.
Gotcha, okay.
Mr. Chairman, may I help?
Yes.
So the first document is really, even though it's not titled that, it's a motion to approve the application. And again, I would strongly suggest that the town adopt the revised version that Abby and I worked on, but again, that's up to you. And the other document is the conservation restriction itself, which again, as I have said before, I would strongly recommend that you approve, obviously with the caveat that the town in Red Wing has to approve it too, but to the extent possible that it match the restrictions to all other properties in the subdivision, to the extent possible, to alleviate whatever you believe has been a hardship on this family, on these property owners. And again, with the caveat that obviously anything you decide vis-a-vis the conservation easement will be contingent upon the town in Red Wing approving it, because you don't have the legal authority to give these property owners what they want without that. So, and if there's any questions, let me know.
Isn't that what the motion on the floor?
Yeah,
Yeah, that's where we are.
We have Red Wings in approval.
Right, well, we don't have the town.
No, not the top here.
Okay, Brian, I was looking to see if you wanted to speak next. Go ahead.
Just as part of the discussion, I want to put on the record the fact that we're evaluating this and voting based upon the hardship that these people have suffered,
Yeah.
based upon poor information, poor communication, and perhaps somebody acting outside of authority in the past.
Very good. Any other discussion? Martin?
Again, the landowner had notice of the restriction when they purchased the property. It was on the deed. First of all, secondly, there was no hardship with benefits. They didn't suffer any harm by anybody's action. They suffered benefits. They benefited from the other person's actions. And lastly, if you're treating one lot differently than all the other lots subject to the same restriction, I don't think that's good policy. It doesn't prevent, we're still talking about other lots within this development, but if we just approved a subdivision on West Main Street, a 3-lot subdivision, they had Red Wing as the steward of the wetlands, if they're willing to erase their responsibility to amend the restriction to allow landowners to do whatever they want. It raises questions about that landowner on West Main Street coming in and doing the same, asking for the same. So I don't see any rationale for treating not any different than landowner will put on notice when you purchase the lot and what's restrictions. I don't see any hardship, I don't see any harm. Not being able to build a swimming pool is not a harm. Basically.
Thank you. Good.
Just like to kind of piggyback off of what Mr. Jaffe said, I agree. I think that this backyard has been used pretty well for over 10 years, and from what I remember from what the property owners had said was that 10 years ago, they didn't put the pool in because they had small children, so it didn't fit their lifestyle at that time. And now that their lifestyle has changed, they want to encroach on areas that are protected. And, you know, they have a driveway because a builder decided not to listen to that protection, right? So you have a driveway because of that. I feel like this would be a double harm. We have already had areas on the property, whether it was approval of the propane tank or a playscape that you benefited from, and you have been able to.
The directing.
Oh, sorry. That the property owners have benefited from, that they have used their land and their property for the past 10 years, and there haven't been any issues up until now when they want to use a pool. So I don't feel like having a pool is necessarily a hardship. I think it's just a lifestyle change that they want, and it comes at the consequences of changing a conservation lines, but also then opening us up to other people in the neighborhood who would want to do the same and feel that, you know, we were somehow favoring certain landowners over others.
Thank you. Any other comment? Okay, hearing none, I would like to have a vote on this. Paul, first, for all those in favor, if you would say aye.
Okay, so they, and I is a vote to approve the conservation.
Correct.
Do you want to vote for vote?
Well, yeah, why don't we do a roll call to be safe? Just to make sure.
Ellen Dahlgren,
Aye.
Eddie Alberino.
Aye.
Mike Florio,
Aye.
Martin Jaffe,
Nay,
Adam Moore,
Aye.
Cynthia Lettieri,
Yay.
Bo Clark,
aye.
Jay Mandel,
Aye.
Okay. It is passed, we're approved the revised motion. And again, we do need the plans revised without the pool.
Very good. Thank you so much, all.
Thank you.
Okay. Now we'll go to the public hearing for the proposed text amendment of section 14 vendors. Abby, can you you're listed as the applicant, I know it's on the website. It's actually here from our regulations committee, not for the Abby, but
I'm the one who uploaded the file originally, and so that's why it is me as the applicant, but yes, this is an application. This is an action to amend section 14 of the regulations relative to vendors that was proposed by the regulations committee and then brought forward to the full commission. Some of the main changes, so there's a staff report that accompanies this, as well as clean and red line copies that were part of the record. We met our notice requirements, so just to sort of get that housekeeping piece out of the way. To refresh folks' memory who haven't been either here yet or were not participating in the regulatory or the regulations committee piece, the vendor section in our regulations had a couple of pieces that were a little bit onerous for folks who were doing work in town. One of them was event vendor permits, and we have actually looked at removing those pieces so that every single vendor at an event does not have to separately permit their presence at that event. So right now, under the current regulations, vendors who are perhaps, participating in the beer festival or, at the fireworks and Summerfest, each one of those food trucks, craft vendors, anybody doing business at that location is technically supposed to come and get their own individual zoning permit, in addition to the main event permit that goes on. And so what's happening is folks vendors are either applying in good faith and paying a fee, and some are not, and so it's not equitable across the board. Or it's just the fundamentals of Kathy is getting 5 permits coming in for one event where she could have one single coordinated permit. So what this modification aims to do is move that language to not require each of those folks who are sort of a sub-vendor under a main event to come in and get those particular permits. Other categories of vendor, stationary vendors, we would leave in place. So people who are going to come and set up on a particular piece of property would still need to have a zoning review to make sure they have the property owner approval, that they're not in setbacks, that they're managing their garbage, doing things, within reasonable hours, those types of things. We've proposed to remove transient vendor from the regulations entirely. This is what you would sort of look at as your peddlers, your folks going door to door, doing particular activities, people who are not stationed on one particular piece of property. 2 things about that, the police actually through the Clinton Town ordinances regulate that activity already and separately. They do any kind of background checking and licensing and all that kind of stuff. And also these are folks going door to door, not necessarily a land use, but an activity. And so we wanted to sort of divorce the zoning regulations from this transient activity versus people who are going to be physically on a property for a good piece of time. So again, it takes some of the duplicative efforts out of staff review, makes it clearer for the vendors when they're in that transient phase, and then hopefully takes out some of the paperwork, makes it easier for folks to do business and get the permit from the agency that is best suited to review. And then seasonal outdoor use is another type of vendor that we have in section 14, and that remained the same. So there's no changes there. That's folks who are setting up on a particular piece of property, doing outdoor dining, retail, or limited entertainment for up to 6 months per year. So if they want to,
Excuse me, like the ice cream truck that was behind us.
so I think that would have been a stationary vendor, right?
If the ice cream truck is stationed for a certain period of time, and it's.
Is that okay?
Like if they're there from say 4 to 6, if they're just driving around, that would be,
No, I'm talking about the one that used to be parked out here.
then that would be stationary because they'd be there for a certain period of time.
But if somebody were, say, having like a Shanks scenario in which folks are, sort of we're permitted into the vendor category, however, they're really in place for a period of time throughout the year, that would be something to fall on that potentially that's
I understand, thank you.
So again, it has to do with the length of time they're there and whether or not they're moving from place to place. Stationary vendors sometimes will come in the morning to a certain location and set up for 4 hours, and then they go to another location and set up for 4 hours. That's a little different from the transients who are literally going door to door and the ice cream truck going down the street.
So you get those cards on your window that they've been to the house player for those who transit. I really don't have any authority over those. Usually that's the police department. If there's an issue with people who call police.
Yep. But right now, if somebody is, if somebody is, saying, hey, I'm from Anderson Windows and I'm trying to, give you a deal, they're technically supposed to come in and get a zoning compliance permit for that, which doesn't really add up in terms of the purposes of the zoning regulations. So that's the reason behind this particular proposed set of changes. And again, it was well vetted through the regulations committee and brought back out for public comment.
Any questions or comments from the commission before I open this up to the public? Okay. This is a public hearing. We are recording both the audio and the video today. If you are interested in speaking on this application to amend the regulations, feel free to let us know. We'd ask that you give us your name and address so that we can record it in the record. Okay, we do have people in the audience, but nobody interested in speaking on this application. Is there a motion to approve?
I'll make a motion.
Shall we make a motion to close the public hearing?
Great motion.
Oh, that's right.
Second.
I got 2 other things to go through on the public hearing. Shouldn't we finish those?
We
Here.
close this application. Right.
And that's true.
Close the public hearing on this
On
application.
this application, yes. No, not close the other 2 items out.
So I'd like to make a motion to close the public hearing on PZC 23-14, which is a proposed text amendment to section 14 vendors.
Did we get a second on that? Okay. Okay, all those in favor? Aye. Opposed? Abstaining, motion carries, thank you. Let me get back to my agenda. Okay. Next item is planning and zoning commission 2315. Amendment to 27.2 non-residential schedule of uses. Again, we have a staff report on this. Or you want to go ahead and summarize it, Debbie?
Sure, so this is a proposed amendment to section 27.2 of the Clinton zoning regulations, which is scheduled uses for commercial properties. So this is not relative to the residential zones. Again, this is something that went through the regulations committee, was discussed at length multiple times, and is an aim to clarify the schedule of uses in section 27. Right now, we have a series of elements relative to sizes of particular uses. For example, the example we used in the staff report was business and professional offices in certain zones have up to 4 different ways in which they're measured, and a category called not applicable in the zoning use table. And that not applicable has led to some pretty significant confusion with our applicants. And we're trying to provide clarity and make the zoning regulations, transparent and approachable for folks to understand what will be required of them. So what we found is there's a historic interpretation that not applicable is synonymous with the X term, the prohibited. However, that's not defined anywhere. It's simply, it's sort of this extra category that has no definition. So in an effort to remove that not applicable and remove some of that confusion, we've taken those out, and wherever a non-applicable was removed, we also tried to clarify those 4 different categories of size and use, so that we're not measuring in multiple ways for the same kind of use. Because again, folks are getting a little bit turned around on, well, if I don't qualify for ground floor area, but I do qualify as occupying, maybe I can get my use in. And so people were sort of coming in, we're having a lot of conversation, it was a little bit circular. So this is an effort to fix that. And so as you go through the table, there are areas where things have been modified into footprint as the unit of measurement and broken up into 3 categories. Footprints less than or equal to 5,000 square feet, between 5,000 square feet and 15,000 square feet, and the footprint greater than 15,000 square feet. That footprint will match the new definitions that go into effect August 1st that was voted on at the last meeting. And what that will do is just lend some clarity to the whole sort of confusion over this not applicable. The other piece of that is we tried to replicate the intent and intensity of the previous 4 categories into these 3 buckets. And so, we were sort of upzoning or taking away any rights from anybody who might have been expecting to be able to build a building of a certain size in a particular zone, but also not, especially in like village zones and those types of smaller commercial areas, not trying to do more than what was seemed to be originally intended in the regulations. And so that was some of the discussion in the regulations committee, was trying to stay consistent with what the effect of the existing zoning was intended to be, but clarify it so that applicants can understand what standards that we measure by.
I will say that it got really confusing when you looked at not happening. That just didn't make any sense. And so this is, again, we want people to actually know what standards they're going to be judged by. And I'm very pleased with what the regulations committee did, and I'm trying to get that through. There are any other comments or questions from the commission? Okay. By the way, you are eligible to speak during the public meeting. Okay. With that, is there anyone from the public who would like to comment on these changes to proposed changes to the regulation? Hearing none, we have a motion to close the public hearing. Make a motion to close the public hearing.
I'll second that.
Then you do vote. Thank you. Ed?
I'm sorry, who seconded?
Well,
Vote,
Thank
chat,
you.
vote.
and then, all those in favor? Opposed? Name, motion carries, thank you. Okay, now we go to, Planning and Zoning Commission 23-19 zoning map amendment to rezone. Oh, I'm wrong.
Yeah.
All right, I'm out of place here. BZ 2316, proposed amendment to section 23 parking. Again, this is, applicant Planning and Zoning Commission. This, we had a lot of good discussion in the regulations committee about also.
So, the amendments to section 33 parking have three main components to them. And so number one is updating the number of required parking spaces for dwelling units to be consistent with Public Act 2129. That Public Act went into effect and modified the number of parking spaces, that the minimum number that people have to comply with for multifamily units. And so we went ahead and we updated to make sure that our studio inefficiencies had no more than one parking space required per unit. And then right now we're over that in our current regulations. So that's a legislative consistency piece. Two, Public Act 2225 was legislation at the state level to require electrical vehicle charging infrastructure to support electric vehicle charging in parking lots that would have more than 30 spaces for cars or light duty trucks. That's for commercial and multifamily properties. And so that this the language has been updated to include provisions to be consistent with that requirement. And then the last piece is our regulations were silent previous to this on accessibility in parking spaces. A lot of those standards are governed by the American Disabilities Act, the building code, but what we wanted to do is at least reference. We had some folks call just sort of saying, why is it that there is no reference, even the word accessibility, I think we have only appeared in one place in our regulations at all. And so this is an effort to at least point folks in the right direction when they're doing their site planning, when they're doing their parking lot design, to make sure that those pieces are covered, and that it's clear that in order to be zoning compliant, you have to meet those accessibility provisions.
Excuse me, is that what we're doing on Stevens Road with the angle, remember I brought that up, that went measuring? Was it wide enough?
So that would be
The angles,
that would be the angle, so that would be more about the sort of the safety and sort of that piece. The accessibility standards are really more related to the dimensions of the number and dimensions of handicap spaces that are required, how to post them, what the slopes of the ground can be relative to the building entrance across the parking lots, and making sure they're striped appropriately and marked in the correct way. So that's really what that's for.
Thank you. Any discussion from the commission?
Just for clarification, so it sounds like virtually everything here is bringing our regs into compliance with existing state and federal law. Correct?
Is there anyone from the public who would like to comment on these proposed regulations? Hearing none, can I have a motion to close the public hearing? So moved.
I second.
Thank you. With that, we'll move on to application reviews.
But we're gonna vote on that.
Well, we actually, it's on the agenda down below under application.
No, we have to vote on.
Oh.
We made a vote.
Thank you. I get ahead of myself. I apologize. Thank you.
it's quick,
And I'm trying to keep it moving. I apologize. Okay, application reviews. The first one is Planning and Zoning Commission 23-13, 23 West Main Street. This is the change of use for this site. There is an agent or applicant. Now is the time to present. Members of Chairman. Yeah, make sure you speak up. I don't know how good this microphone is.
Thank you, Chairman, officials, and members of the commission. The applicant is looking to
received the site plan approval tonight for a change of use of 23 West Main Street, which is currently a podiatrist's office.
My doctor's office.
And we're going to change it to retail and a tea room. We received all the approvals from health, fire marshal, signage. It does comply, of course, with the zoning. The fire marshal had one comment. There was going to be a salt room in the basement, but he wanted extensive renovation work in order to accommodate the access from the back of the building. It would just cost prohibitive, and it would have had major renovations to the exterior. So instead of that, they decided to abandon that and have just one salt room on the first floor, which was in the original plan, with one exception. The double doors, you have that? The double doors on the side of the building, the John Street side, you know the property? The property on John Street is perpendicular, of course, to the street. Then there's an inset in the building about 4 feet. And there are double doors leading into the back space of the building. We'd like to leave those there and put a one door about 4 feet to the left of it, which would give access into the back room. And then the salt room would be in front of the doors on the inside, which doesn't really impact the exterior at all. That's basically it.
There's 2 images in there. I'm sorry.
Thank you. This, so again, this is a change of use.
What is the salt? I gotta
The salt room is when you go to the beach and you smell the salt air, you're invigorated. Well, the salt room will miss a salt that people with any respiratory ailments or skin ailments feel relieved. Makes them feel good, and it's coming in our area soon. And a number of them are popping up now. Anybody have a question on the commission?
No, I just learned something.
I do have one question. I mean, the application states right here that it's still plus adding the salt therapy room in the basement. Has that application been modified to not show the?
So you're modifying it now, yes, because of course prohibitive.
Okay, but do we have a plan to show that without?
We do not, no, and so I think the one of the findings and one of the modified pieces in here would need to be that the applicant has stated on the record that the basement would not be used for this particular use. So that would be part of the decision, and then the only real places that affects anything in terms of the recommendation is relative to the excusal of the parking, the on-site parking requirements. Those residential spaces are still in the lot, so that doesn't change anything. And if anything, it's to the benefit because there's fewer off-site spaces required to support the use. So it doesn't have a negative effect in terms of that particular decision. But I would add a finding that the applicant during the course of the presentation indicated that the basement pieces shown on the plan would not be.
Make that a condition.
Yes.
Do you want to show on the screen there? So that door.
So,
you know what I mean, but then
Matthew,
mailboxes.
So this is John Street running parallel to the building. CVS is right across. So as you're running toward the back, the building cuts in. There's an inset. And you have that next slide, please.
July 10th. That's probably the image right here.
That's it, that's the one. So this is the rear of the building, and the salt room would be just in back of these double doors. So we'd leave those in place, and roughly 4 feet away is an air conditioner in a window that would be removed and put in one door, a 3-foot by 7-foot outswinging door.
And Jeff signed off on this? The fire marshal signed off?
Yes, he signed off on the first floor. He said, but there was concern using the basement for salt room. So he saw the plan, he was on the premises, he approved that. And I have it writing, the board has it writing. as well.
Correct, there's review from the fire marshal in the record, and he's been into discussion with staff as well, that some of the egress components and.
Egress, yeah.
Yeah, that was the basic.
We did approve it. We already have a sign approval, and we just be looking for the approval tonight. Site plan, so we can get going with it.
Before I say anything, is my doctor still gonna be around?
Not this location, but he has 2 other locations, yes. Okay, I would entertain a motion to approve this site plan with the condition that the plan be modified so that the basement use is not in there. And we've got testimony from the applicant that that's their plan. So moved.
Second.
Second, okay? Yes.
So the only point of clarification I had is whether any of the recommended findings from the staff report relative to the excusable parking were to be included, because we want to make sure that their record is clear of what they have rights for.
I'll modify my motion to include your recommendation.
Okay.
So moved. Okay.
Go ahead, we're in.
Question for Abby, is there any particular environmental or disposal requirement? I have no idea what goes on in salt or salt is involved, but I mean, is there any? Does the health department have to buy in on?
So there's permitting for the actual establishment through the health department. And so I believe that there's comments and approval relative to the capacity of septic to handle it. And then any permitting for the actual licensed use, which would go through health as well. Maybe it may be more worthwhile for our operators and owners to talk about what the cleanup, change out of salts or any sort of residual, management of the material might be. Am I aware of any?
That goes through the health.
That would go through health, yeah.
But health does have to, they're aware of all this salt, not just that.
Right, and they know what the application is.
Thank you. Any further discussion from the commission? Okay, with that, all those in favor?
Aye.
The approval?
Approved.
Okay.
Opposed? Abstained? Motion carries. Thank you. Thank you very much.
You're welcome.
I'm sorry, it was Bo who made the motion and Eddie seconded.
Yes, yeah, yes.
Thank you.
Okay. Now we have the public hearings that closed tonight for section 14, which is PZC 2314, the vendors. Is there any discussion on this, or do I hear a motion?
Motion to approve, PCC 23-14.
We an effective date of,
Effective date of
what do you want as our effective date?
It's September 1st, we give us plenty of time.
September, the effective date of September 2023.
Thank you, Mike. Okay. Discussion. All those in favor?
Aye.
Opposed? Then motion carries. Thank you.
Mike, you seconded?
Yes.
Thank you, sir.
Okay. Item B,
Like, can we do more at once?
23.
We've done it before.
So this is text amendment. This is section 27.2. Oh, we had 2 A's. That's what happened.
I'll move to approve, application PCC 2315 with an effective date of September 2024.
Okay. Thank you. Any discussion? Okay, all those in favor?
Aye.
Opposed? Then motion carries.
I'll move to approve PCC 2316 with an effective date of September 2023.
Second again, thank you. Any discussion? All those in favor?
Aye.
Opposed? Then motion carries. Thank you.
We've already done so.
We've already done 7 now. We have correspondence. There's 2 items of correspondence. We have a letter.
And I can't help you with this, just get into things, sorry.
Okay. Letter concerning 89 Commerce Street. And then we have the staff memo, also regarding this. Yeah, that's there. So at this point, what we have are concerns raised by Dr. Martinez. Over, the property at, I had it and we lost it. 89 Commerce Street. With concerns about whether or not it's been, subdivided into a multifamily home. That there is, problems with, heavy duty construction equipment and such. And also issues about blight, and summarizing, obviously. Right now, we have a response from the town that, no, violations were found when it was inspected. The building inspector has been there for open things, for open permits, and has not found any evidence of subdivision of the house. So right now, we really don't have any grounds for, in my opinion, the planning and zoning commission to do anything with this, because the zoning enforcement officer doesn't have any. I would like to hear from the commissioner.
I brought the staff.
Yeah, I mean, it's not a zoning issue, but how long can you leave a permit open? Well,
Yeah, if while this work is progressing, it kind of continues on, I think it's 180 days, and you can confirm with the building official that you have to sort of within that period, finish or be continuing the work. So.
No, I go 2021.
Yeah, but the permits,
Well, only one person talking at a time, because we are being recorded, so then make sure you speak up, but go ahead, Mike, you were.
No, I was gonna say that some contractors never even close out a permit, so they can go on forever, I mean, they go on 20 years, 30 years. It's happened.
Yeah, we've had issues that way.
Right, and there's a difference between permits that remain open, sort of, that never got closed, that should have been closed because the work was done. And fully completed versus permits that are open because the work is ongoing. And so if there's any questions specific to any of these permits, I would say the building official would be the best person to respond to that. It's not really the land use department that can do it.
People have been known to drive a nail once a month to keep a permit up.
Okay, Jay?
A neighbor complained about the work next door to him, is that what happened? I mean,
Yeah, well,
something
at least
that-
there, we have one person who is, Dr. Martinez, who has, documented several complaints or made several complaints. The question for us is whether these are zoning complaints or things that need to be handled, separately.
Also, one other question, if you get a permit, it's open end,
No,
oh, there's a timer.
How long is your time?
I believe it's 180 days.
So there's open permits from 21 coming up.
But if they're continuing to do work, and so
So
relatively.
one room to another section of home.
those are under the jurisdiction of the building.
And that's the distinction here is what is under the purview of zoning is very different.
And what's the correct verbiage for blight?
It's all in documentation.
It had, only one person has to see it.
No, that if you,
You don't have to have multiple people see blight.
like letter and entry.
Okay,
there's a lot of documentation in this file. I've been out to the property multiple times and there's light with this document.
So- but if one person sees blight, that they can make a complaint.
No, the blight, I'm the blight official, and so.
Okay, so if I didn't, if I'm a homeowner next door, not looking for accommodation, looking for closure, but if I'm a neighbor, if I own a home. And I look out and I see blight, I can make a complaint,
Yes.
I don't need anybody from the public.
You can make a
You
complaint.
are
I
the public.
investigate
I am the public.
it, then I
It's my
investigate
home.
it, and then I go and see if it meets the criteria under the
Okay,
ordinance.
so,
I take photographs, I type my report, and
okay,
then if I find that it meets the criteria of the ordinance, then I will do an inspection, and if necessary, I'll send out a notice of violation.
okay, so,
I guess what Ed is trying to make clear here is that the light, for instance, doesn't necessarily have to be seen from a public road. It
Yes,
can be
it
seen
does.
from a neighbor's house.
It's in the ordinance. You have to read the-
Typically, light is applied to the public, and it could be any member of the public, is my understanding.
And any member of the public may make a complaint to the land use office. As a as a potential zoning violation, as a potential blight condition, and keep in mind, these are two separate regulatory streams. One is,
Understood.
right, so we've got the zoning regulations and the blight ordinance.
But if the light, for instance, is hidden from view of the road, but not hidden from the view of a neighbor, it still is blight.
It
Yes, it
doesn't
is.
meet the criteria. There's,
It's
it
what?
says in there, it's from the view of a public way.
But a public way could be the next door neighbor.
Right, but
No,
no,
because
that's
the general
not a public
public,
way.
and, yeah.
Because I can't break curtilage. Curtilage is the area that
I
I'm allowed to
understand.
be. So if it's in the back, that's not blight.
So
I think
it has,
that's a fine line that should be looked at.
The ordinance is very clear.
It's very clear. And also the thing is, there has to be, because in terms of privacy, I can't be big brother to everyone. That's such an invasion of people's privacy. So I'm in public way, and it's very clear what the ordinance covers.
The ordinance shows say the public way, and
That's
that
the
means.
public way, so that's the distinction.
Yes.
Because typically it applies to the public, which could be any member of the
any member of the
public.
public.
but it's visible from a place that anyone in the public could see. Not that a particular homeowner is not a member of the public, but that anyone, that if Joe Smith is walking down the road, Joe Smith can see the condition that is being proposed to be blighted.
So if somebody puts a, just say for the sake of argument, puts a 6-foot fence on their front porch. And the back of the home is a complete disaster, that's not enforceable?
I do my inspection from the public way, which is the street or the sidewalk. I'm not allowed the curtilage, which is in the private area.
Like Stevens Road, before that gentleman died.
Well, Stevens is public way, and that, I'm actually, I'm
Yeah,
very.
but back in, you never see it back.
It doesn't matter, because that whole area is still blighted,
You couldn't, yeah, you couldn't see it, I mean,
but it's under.
okay, I'm gonna be very honest, right? I know both parties. And I went there was so much smoke, it was unbelievable, so I went there, and I said, what are you doing? They said, you can't be burning this. So I said, you gotta put it out immediately. I said, you're killing your neighbors. This is a true story. So I said, what is, there was a bunch of lawnmowers, we had a lot of stuff back there. I said, you gotta get rid of this. And he goes, I don't know how to get rid of it. I said, I'll make a phone call. I made a phone call. I had my friends come down and pull lawnmowers out of it.
And, I'm gonna have the authority to tell people that they have to do that.
I did do that because it was, they were all over the place.
That does not give you the authority to do that. That is, it was an inappropriate thing.
Well, I guess I was inappropriate then.
Well, you were acting as a
Right.
private citizen, not as a member of.
No, it's not, no, I,
Okay.
it's acting like, you know, so what are you doing? I didn't say I was from the planning and zoning.
Okay.
I would never do that, but they moved a lot of the stuff up, you know, and a couple times I went back for, that's why I never cited them. They're burning stuff they shouldn't burn. I told them you can't do that. They used to live next door to me. They said, you can't burn this, you can't burn that. So it was a cultural difference, so I changed, you know, at least changed the habits, you know, of that. But now there's refrigerators back there and stuff. I mean,
First of all, Eddie, that has nothing to do with this,
It's
it's a complaint.
nothing to do with me, but it has something to do with her, if it's on her line of sight. That's all I'm saying. Mr. Chairman, I'm just trying to be fair. If I was gonna try to be a mean person, I'd give them a $500 bill, you know what I mean? Fine. I never did, you know, for burning. I go there for burning, they tell me you can't burn, you can't do this, you can't do that. You know, there are cultural differences and there's cultural.
Now, what we were discussing is whether or not this is a zoning issue or not, and it is not a zoning issue.
Why don't you let her talk? Let her do. I mean,
That was right there.
go ahead.
So I think one of the questions here, so there's, we receive a lot of. I'm not even sure what number complaint we're on at this point in the year. Some are found to meet the criteria of blight, some are not. One of the questions would be what, so again, and again, remember the blight ordinance falls under the purview of town council and then it gets referred through the town manager to Kathy, the assigned person under that ordinance. So a blight discussion is really sort of a town, so the contents of the blight ordinance, so the view from the public, what constitutes blight, because there are other properties that folks are equally upset about, that the blight ordinance may not have the language to pursue. I think.
Ask Kathy, I called her, Abby, with respect, from the ambulance. They said, I'm at a call when I drop paramedic off, and I send you pictures right from the house, in like that. You got it, and she acted upon them from my pictures. From my camera to her phone, I still got, blight, and she taking care of her, so I just try to be helpful,
Yeah.
I just feel bad because it's just too,
It's,
I do, I'm being honest with you, I
it's a
feel
black and
bad.
white system. I have a list of criteria that I carry with me that are from the ordinance. I look at the property, I take photos, and I have a checklist. It meets it or it doesn't.
You take my pictures, correct?
And if it meets the
And I
criteria.
sent you quite a few, I sent it to you.
But I think the important thing is that there may be disagreements in what people's personal threshold and opinion of blight may be.
Or unsightliness.
At the end of the day, Kathy is the person charged as the town official with being the arbiter of that decision. If there's a problem or a disagreement with that decision, the question then becomes, does the blight ordinance contain the appropriate paths for residents, any residents, to march through a process to formally appeal, similar to what we have in the zoning regulations, right? If Kathy issues a decision under zoning, that can be appealed through the zoning board of appeals. And so part of it is procedurally, does the blight ordinance do for the town what the town is hoping it will do? And is that the action of the planning and zoning commission, or is that the action of town council? There are many, again, every single day, we see a wide range of threshold in terms of what is and is not somebody's tolerance for what someone is doing on their property. We have complaints for folks when kids leave their bikes out overnight or have leaves in their yard. And I'm not saying that this is that same condition at all. What I'm saying is the tools in the blight ordinance give Kathy a box to work in. And I think that's, and then sometimes that box does not cover the results that someone is.
So Abby, if I may ask, the blight ordinance would be driven by the town council, correct? Not by planning and zoning. So it seems to me that really that should be suggested to town council, they modify that, because I think it does affect a member of the public, even if it's hidden from the public.
And there are implications to that as well, right? Because then the question is, how much of the zoning official, blight enforcement official, how much of that work is the town doing on behalf of relationships between private property owners? And what should that threshold be? Because there is a cost associated with it. And that.
But it is outlined in the blight ordinance, correct?
Very clearly.
Mhm. Yeah.
Go ahead, Jerry.
You have to be a member of the town to make a complaint.
No,
You can be just driving down and,
I got a complaint the other day from a gentleman who was a renter.
well, rent it, but I'm just.
He doesn't live in town.
But
But
someone.
you do have to identify yourself, right?
He called me and asked me to meet him on coffee, and I had a discussion with him.
So we take the, right now, the complaints come in, whether it's zoning or blight, come into the office through the OpenGov, the online system. So you can find who someone is, they don't have to necessarily put their name in, they can put Mickey Mouse if they wanted to, but an email address is required. Some people will create their own email address and separately, so they can't be traced back. We have a lot of folks who are concerned about retribution and what that means if they complain about their neighbors, they don't feel comfortable, they feel scared. And so we do have ways to do that as well. But yeah, anybody driving through or anybody who's aware of our complaint system could file.
Okay.
And I have another,
She's amazing.
Yeah.
So I just kind of want to bring it back to. You have gone, you've seen this property, it does not meet blight, so now this is out of our hands. If the person, the member of the community would like to go to the town council or file an appeal in some way.
Or a lot of times it's an administrative remedy that would be handled through an attorney.
Okay.
I see a lot of cases between property owners that really, the way I liken it sometimes is if you have a toothache, you don't go to the hairdresser. You know, it sometimes just, it's not that I'm denying, it's not denying there's an issue, it's just the wrong path.
Great.
I have people that talk to me and I say, you really need to speak to an attorney. This is a civil issue. It's not something I can fix.
So it's something we need to vote on for,
This is for fun, there's nothing to do.
And I do have one other question with regards to, this. I know on some of the correspondence that I read, I think it was last month. There was a response from you, Kathy, about definition of family. I don't recall what the response was. But we do define, because I think it was something to the effect of. We cannot define a family, so summarizing that, but we do have the definition of family within our regulations, so something should be changed.
I'll let Abby change that because we did just change it.
Yeah, so I was gonna indicate in the staff memo, so the last meeting, there was a public hearing to actually amend that definition of family, and so I think I put in the old and new definitions into the memo. Taking out the number of people because of the fact that it's, well, the language is in the regulation, we've had this conversation as well, it's clearly there. The ability to enforce it in practical terms doesn't exist. If Kathy goes and says, I want to see your birth certificate, marriage license, and how you're related to those three people there to make sure you're under your threshold of people who are unrelated living together, or the language currently says domestic servants, which is a little bit antiquated, that if they say no, there's no recourse. And there have been cases throughout the state about people, you know, cohabitating where number definitions have not been upheld. And so that was the reason for removing it. So that actually goes to the public hearing was at the last meeting. Folks had the opportunity to, you know, to speak on that, and the commission voted unanimously to adopt the regulations to be effective August 1st.
This is the definition. Any further discussion on this from the commission? With that, I then would like to move on to adjournment. Motion to adjourn. Second from Mike. Okay. All those in favor? Aye. Join the legal report. You can stop.